It's now my great pleasure to introduce our next speaker. Justice Jackson is a graduate of the University of Queensland, where he holds a Bachelor of Laws degree. In 1977, Justice Jackson was admitted as a barrister of the Supreme Court of Queensland before being appointed a Queen's Counsel in 1990. He quickly cemented his reputation as a leader of the commercial and appellate bar here in Queensland. Substantial corporate commercial work was the focus of his practice, but he was in demand in other areas as well, appearing, for example, on behalf of the pastoralists in the Wick People's case in the High Court of Australia, and on behalf of Air Services Australia in its High Court litigation against Canadian Airlines. Justice Jackson was a member and director of the Council of the Bar Association of Queensland, and then in 2012 he was appointed a judge of the Supreme Court of Queensland. His honours swearing-in ceremony was the first to be conducted in the Banco Court of the Queen Elizabeth II Courts of Law, and the then Chief Justice, now Governor of Queensland, Paul de Jersey, said that His Honour would make an outstanding addition to the Supreme Court of Queensland on account of his widely accepted intellectual preeminence. And so his addition has been. In addition, since 2014, he has chaired the Queensland Law Reform Commission. He will be speaking this morning on McCawley and other cases in light of Kirk. Are there unrecognised possible limitations on the state's powers of constitutional amendment derived from the Commonwealth Constitution? Please join me in welcoming Justice Jackson.
The Honourable Ian Callan, AC, President of the Society. Other distinguished guests, ladies and gentlemen, including colleagues in the legal profession. My apologies for being late, and my thanks to Associate Professor Hollander for changing the order of the speeches. May I say I'm delighted to speak at the Society that honours Sir Samuel Griffith. We locals regard the High Court judges from our state with parochial pride, including your President and the 4 exceptional Queenslanders who've been appointed Chief Justice of the High Court of Australia, or Chief Justice of Australia as it's more accurately known. Subconsciously, I've chosen maroon as the background colour for my presentation, but I notice it's also the background colour of the Society's logo. Sir Samuel was first and rightly the most famous among them, and it's fitting that this Society bears his name. The title of my presentation gives away the point of it, but I should begin by warning you not to expect too much. There's no ticking time bomb about to explode on current constitutional thinking about the limits of the state's powers of constitutional amendment, at least as far as I know. With that disclaimer, may I dive into the topic, and I'm going to make you read a fair bit. I apologise, but this is the best way I think to show it to you. By starting at the chronological end, namely the 2009 judgment of the High Court of Australia in Kirk and the Industrial Court of New South Wales. The relevant constitutional question arose in Kirk because Section 179 of the Industrial Relations Act, that section provided that a decision of the Industrial Court was final and mightn't be appealed by any process, quashing and others as is set out, or called into question by any court or tribunal. The constitutional question was resolved by the court holding that Section 179 was invalid as beyond the legislative power of the state to alter the constitutional character of its Supreme Court, so that it would cease to meet the constitutional description of the Supreme Court of a state that appears in Section 73 of the Australian Constitution. The relevant part of Section 73 should go up on the screen. There were 2 steps in the reasoning in Kirk. The first was to identify the principle or limit upon state legislative power, and the second was to characterise Section 179 as infringing that principle. As to the first of those steps, the principle was succinctly stated in paragraph 96 of the reasons of the plurality in the court. It goes on the screen now. The second step was equally important, and the gist of it was set out in paragraph 99 of the reasons of the plurality. The critical part of that paragraph is the second half of it, which should go up on the screen now. Having said that, the plurality immediately went on to say that doesn't mean no legislation can affect the availability of judicial review in a Supreme Court. The distinction between what is within legislative power and what is outside it is the distinction between jurisdictional error and non-jurisdictional error. So that legislation which would take from a court of a state power to grant relief on account of jurisdictional error is beyond state legislative power. The Kirk principle is directly derived from the principles expounded in 1996 in Cable and the Director of Public Prosecutions. Other decisions stemming from Cable can be seen also to turn on this notion of the constitutionally guaranteed institutional integrity of the Supreme Court. One example in Queensland is that legislation by which the Attorney-General would have been able to reverse a decision of the Supreme Court made under the Dangerous Prisoners Sexual Offenders Act was held to be invalid. The point of interest for this morning is that the Court of Appeal rejected an argument that the Cable principles are limited to provisions that try to confer a power on a court that is repugnant to the court's institutional integrity. In that case, they struck down another act because it would diminish the way in which the court's decision was held. One might say, well, that's all very well, but what's it have to do with McCawley's case? If you'll bear with me for a little longer before I get to McCawley, there's another relevant case that deals with the limit of the power of a state parliament to make legislative changes to the Supreme Court. It's the 2006 decision of the High Court in Forge and others and the Australian Securities and Investment Commission. The question in Forge was whether it was beyond the legislative power of the state, New South Wales in this case, to provide for the appointment of an acting judge as a judge of the Supreme Court. Specifically, the question was whether Section 37 of the Supreme Court Act 1970 that permitted such an appointment was invalid. Parts of Section 37 are on the screen now. The High Court held that Section 37 was valid. The Court proceeded by the same two-step reasoning process followed in Kirk, and the first step as to the principle was the same as in Kirk. One important point about Forge, though, is that it reframed the constitutional principle as it was articulated in Cable in a way that more directly applies to assessing the limit of the state's constitutional power to affect its Supreme Court. The way that was done in Forge appears in paragraph 63 of the reasons of the plurality. The whole paragraph is too big a slab of text to put up on the screen, but the most important parts are on the screen now. In this way, the principle has emerged that the question is whether the amendment would impermissibly interfere with the institutional integrity of the Supreme Court. On the second step of the reasoning in Forge, there were a number of reasons for the Court's conclusion that a power to appoint some acting judges does not affect institutional integrity. I don't need to talk about them in any detail. One obvious point was that even at the time of federation, there'd already been numerous appointments of acting judges of Supreme Courts. In fact, two of the three first justices of the High Court had been acting judges of the Supreme Court at some point, as were later appointees. But the important point about Forge for this morning's purposes is what was said by the plurality in paragraph 73. Again, the whole of this paragraph is too big a slab of text to put on the screen, so to simplify things, may I summarise the first two steps of the reasoning. The first was that the way that the Supreme Court Act 1970 distinguished between acting and permanent appointments would not permit the appointment of so many acting judges that the court was predominantly or chiefly composed of acting judges. The second was that that limit could be seen as following either from the words of the Act or as reinforced or required by constitutional considerations. And it is a conclusion that proceeds from an unstated premise about what constitutes a court. It's the next two paragraphs or sentences of paragraph 73 that are of the most interest that are on the screen now. Now, I would make two observations about that passage. The first is that this reasoning, at the least, suggests that the scope of the power of the state to alter the constitution of the Supreme Court by providing for the appointment of acting judges for a limited term is not absolute. And the second is that the reference to permanent judges who have tenure to a set retirement ages raises a relevant diversion. At the time of federation, the judges of the Supreme Court of the states were appointed for life by words that appointed them, quote, during good behaviour, unquote. The first Australian legislation that required a judge to retire at age 70 was passed in Queensland in 1921. Some may think that a retirement age of 70 or similar years is a logical thing to prevent those of waning powers from continuing when they should retire. At least enough people thought so to pass the referendum in 1977 that altered the Commonwealth Constitution to introduce a retirement age for High Court judges. But perhaps that in part was the reason for the Queensland legislation of 1921, but it at the time had a second purpose. There was a long-running antagonism then between the government of the day and the Supreme Court. And compulsory retirement was applied not just to future judges, but to the existing members of the Supreme Court, and brought about the immediate retirement of 3 of the 5 judges of the court. McCawley's case itself was an earlier part of this long-running antagonism. The Queensland legislation may be contrasted with other similar retirement legislations, such as the amendments in 1977 to Section 72 of the Australian Constitution, that did not apply or do not apply to existing judges. To come back to the point of, or chief point of present interest, in 1915, T.W. McCawley was the Crown Solicitor. He was an admitted barrister who had never practised. He was handpicked as the Under-Secretary for Justice by T.J. Ryan, who was then the Premier and Attorney General. Ryan was a skilled practising barrister, although not then a silk. On 12 January 1917, aged 35 years, McCawley was appointed as a judge and president of the new Court of Industrial Arbitration in Queensland under Section 6 of the Industrial Arbitration Act of 1916, and parts of Section 6, subsection 6 appear on the screen now. This is part of a much broader story about the fight between the Labor Party and Conservative governments at the time over industrial relations, but I don't have time to talk about that. Under Section 6, the appointment was for a period of 7 years from the date of the commission. On 12 October 1917, also under Section 6, McCawley was additionally appointed a judge of the Supreme Court of Queensland. It was generally accepted that the additional appointment as a Supreme Court judge should be construed as being for a term of 7 years, being so long as he was appointed judge of the Court of Industrial Arbitration. On 6 December 1917, McCawley presented his commission to the Chief Justice, but there was an objection to its validity. Tensions ran high at the time, and the appointment even stirred religious sectarianism. The Church of England Archbishop denounced it as part of a Catholic plot to take over the legal profession. Needless to say, the Roman Catholic Archbishop of the time, the famous figure of James Dewey, responded in kind. The case for McCawley was argued personally by T.J. Ryan. The ongoing antagonism between the government and the Supreme Court can be seen in some of the exchanges between Ryan and the court during argument. The main argument for invalidity was that Section 6, subsection 6, was ultra vires and contrary to the provisions of the Constitution of Queensland. The relevant section, or most relevant section of the Constitution Act, was Section 15, and it's set out on the screen. There were some procedural hiccups, but ultimately, on 25 April 1918, the Supreme Court made an order that McCawley was not entitled to take a seat as a member of the Supreme Court. On 27 September 1918, the High Court dismissed an appeal by a majority of 4-3. It decided that Section 6, subsection 6 was invalid because it was inconsistent with Section 15. The effect of Section 15 was that the commission of a judge of the Supreme Court shall be during good behaviour and impliedly for life, not for a fixed term. Those provisions, or that provision, hadn't been repealed because Section 6, subsection 6 purported to authorise an appointment of a judge for 7 years. It was inconsistent and invalid. You'll get the flavour of how the case was dealt with by the majority of the court from a passage from Chief Justice Griffith's reasons from page 22. But the point of the majority reasons was not that it was beyond the power of the state to alter the Supreme Court in a way that affected institutional integrity. It was that before Parliament could alter the tenure of the appointment of a judge by some other act, an amendment had to be made to the Constitution of Queensland first, so as to avoid inconsistency. Before we leave the High Court in McCawley behind, one other point to note is that both Chief Justice Griffith and Justice Barton referred to Section 106 of the Australian Constitution, which provides that the Constitution of each state of the Commonwealth shall, subject to this Constitution, continue as at the establishment of the Commonwealth until altered in accordance with the Constitution of the state. This, Sir Samuel said, gave the provisions of the Constitution of Queensland that reflected the Act of Settlement the force of an imperial statute. Justice Barton also referred to Section 106 as giving support to the character of the Constitution of Queensland as a constitution. On 8 March 1920, the Privy Council allowed McCawley's appeal from the High Court. From what I've said so far, you might be expecting that when the case got to the Privy Council, it would have focused on some of the questions I've mentioned about the detailed operation of the Constitution of Queensland and perhaps consideration of its context in the Australian Constitution. Not in the least bit. The dispositive reasoning of the Privy Council begins at pages 114 and 115 with the distinction their lordships drew between a controlled constitution and an uncontrolled constitution, and they continued with the passage which is now set out on the screen. If I may be forgiven one aside, I've always wondered whether the Privy Council would have used the example of amendment by the Dog Act if they'd been talking of amendment to a fundamental British constitutional act rather than the Constitution of Queensland. One source I've read says that McCawley's counsel were not called on in the oral argument of the appeal. The Attorney-General for England intervened in the appeal and his counsel made submissions about the extent to which the Imperial Parliament had intended to devolve constitutional power on colonial parliaments when erecting the colonies. These points do not appear in the report, in the law reports. Nowhere in the Privy Council's reasons is any reference made to the fact that the Constitution of Queensland was the constitution of a state and subject to the Australian Constitution under Section 106. So far as the Privy Council were concerned, the ability of the Australian colonies to amend their own constitutions was entrenched by the Colonial Laws Validity Act in Section 5, in part as set out on the screen. The result was that on 3 May 1920, McCawley took up office as a judge of the Supreme Court. Within 2 years, as I've already mentioned, 3 of the judges who'd sat on McCawley's case in the Supreme Court were removed from office, effective 31 March 1922, by an act based on the holding in McCawley that an ordinary act could repeal the constitutional provision for the life tenure of a judge. From what I've said so far, however, one might think that the only relevant question raised by the reasoning in Kirk and Forge concerns the constitution of the Supreme Court of any state. But although I acknowledge that this next step goes out on a limb, there might be a bit more to it. Some of you may remember the appointment of Senator Albert Patrick Field during the turbulent period between 1973 and 1975. On 30 June 1975, Queensland Labor Senator Bert Milner died. The Queensland Parliament, comprised of the Legislative Assembly, led by the Premier Joh Bjelke-Petersen, appointed Field, who was a public servant immediately before his appointment. In any event, famously or infamously, depending on your view of it, on 11 November 1975 there was a double dissolution, and Field was not elected at the 13 December 1975 election. The underlying point of that history is that, as at 1975, Section 15 of the Constitution, the Australian Constitution, provided in part as is now set out on the screen. Note the reference to Houses of Parliament, plural. Of course, since 1922 there'd been no Legislative Council of the Parliament of Queensland, even though there was one as provided for in the Constitution of Queensland at the time of Federation. As you may know, in the 1977 constitutional amendments, Section 15 was replaced. It now provides for the contingency if there is only one House of Parliament of a state for which the senator is to be chosen, and the relevant part of the current section is on the screen now. I hope, yes. But bear with me for a few minutes while I explore what might have been the consequences of the statutory assumption in Section 15, as originally enacted, that there would be Houses of Parliament, plural, of a state. This part of the journey around the cases begins with Taylor and the Attorney General, another Queensland case brought to the High Court in 1917. It was another case that arose during the long period of antagonism between the government of the day and the Supreme Court. Ryan, as Attorney General and Premier, again argued the case for the government. The question was whether the Parliamentary Bills Referendum Act 1908, which I'll call the Referendum Act, was valid to permit the passage of a bill to amend the Constitution of Queensland by abolishing the Legislative Council without the bill passing through the Legislative Council. Bear in mind that this case was decided only a year before McCawley, and the leading judgment at the time was that of Justice Barton, and the key passage is set out on the screen. He held that Section 5 of the Colonial Laws Validity Act gave full power to make laws respecting the constitution of the legislature, meaning the composition, form or nature of the House of the legislature, where there's only one House, or of either House if the legislative body consists of two Houses. He held that power covered the provision in the Referendum Act that a bill passed by the Legislative Assembly in two successive sessions that has in the same two sessions been rejected in the Legislative Council may be submitted by referendum to the electors, and if affirmed by them, may be presented to the Governor for royal assent. Ultimately, the Legislative Council was got rid of in Queensland, but it was not by the mechanism of a referendum under the Referendum Act. There was such a referendum on 5 May 1917, but it was lost by the government, and the circumstances surrounding that are an interesting piece of history itself. But in 1921, after McCawley's case, the government swamped the Legislative Council by appointing additional members who voted in favour of a bill to abolish the Legislative Council. And in that way, Queensland became a unicameral parliament. One point of interest for present purposes is that at that stage, no one seems to have thought that the assumption in Section 15 of the Australian Constitution that there would be two houses of state parliament might restrict the ability of a state parliament to abolish its legislative council, or its legislative assembly for that matter. Perhaps two other contextual points should be made. One is that although each of the Australian colonies that became a state was erected with a bicameral parliament, some of the Canadian provinces, as at Federation, had only one house. British Columbia is an example. So the concept of representative democracy with one House of Parliament was not unknown. The other is that Taylor's case and McCawley's case were both decided before the Engineers case. There were later cases about the powers of a state parliament to legislate for or against the abolition of the Legislative Council. In particular, in 1931, in Attorney General New South Wales and Trethowan, there was a challenge in the High Court to the validity of legislation that did not comply with Section 7A of the Constitution Act 1902, which set up a requirement for a referendum before the Legislative Council could be abolished, and the relevant parts of it are on the screen. However, in 1960, there was a more interesting case for this morning's purposes in Clayton and Heffron. The main question in Clayton was whether Section 5 capital B of the Constitution Act 1902 was invalid. Section 5 capital B was introduced to deal with the contingency that the Legislative Council might refuse to pass a bill which provided a mechanism to bypass that House and go directly to referendum, like the earlier Referendum Act in Queensland. The relevant part of Section 5 capital B is on the screen. In effect, the High Court held that both provisions were manner and form provisions that would have to be complied with under Section 5 of the Colonial Laws Validity Act, and therefore operated outside the ability of the Parliament of the state to amend by an ordinary act. But of interest for this morning, though, is that the validity of both Section 7 capital A and 5 capital B as a method to abolish the Legislative Council was challenged based on the reference in Section 15 of the Australian Constitution to the Houses of Parliament. The plurality of the court described this as a somewhat curious point, and then they said what follows on the screen. The similar argument to the one that now prevails in relation to Kirk was described as not a very cogent argument. So, ladies and gentlemen, you may think that I've come a full circle. I started with an argument, now accepted as good constitutional law, that the reference to the Supreme Court of any state in Chapter 3 of the Australian Constitution assumes and requires that there shall be a Supreme Court of the state, with the consequence that the power of the state parliament to legislate with respect to the Supreme Court is constrained to the extent that the institutional integrity of the court is not diminished. That principle crystallised in 2006 and 2010 from beginnings in earlier cases like Cable. Yet that point was not even an argument that was raised at the time of the great debate about the extent of the state's power to amend its constitution to interfere with the constitution of the Supreme Court by appointing judges for a limited term in McCawley's case. On the other hand, there was an analogous argument that the references in Section 15 of the Australian Constitution as to the Houses of Parliament of a state and the continued existence of those houses was assumed, with the consequence that the state's power to legislate to abolish one of those houses is constrained, so that, and these are my words, the institutional integrity of the Parliament is not diminished, was rejected. That point too was not an argument raised in the great debates in the cases between 1916 and 1931 about the power of a state parliament to legislate to abolish its legislative council. Perhaps this particular arguable inconsistency never needs to be resolved. In a practical sense, the Houses of Parliament plural argument disappeared in 1977 with the amendment of Section 15 of the Australian Constitution. But is this the end of similar arguments? Up to this point, there hasn't been a great deal of exploration of the limitation of the legislative powers of the state parliaments created by making the constitutions of the states subject to the Australian Constitution under Section 106. The questions that remain, or the question that remains, is where will Kirk take us from here, if anywhere at all? And the suggestions I would offer up are as follows. First, it must at least now be arguable that in the light of Kirk and Forge, McCawley's case was wrongly decided, to the extent that it suggests that the Parliament of a state may generally appoint judges of the Supreme Court for a term such as 7 years. This may matter. For example, a reforming government may desire to appoint judges of a Supreme Court for a limited term and to require them to face re-election for extensions of their term, as has happened in a number of states in the United States. Second, there may still be scope for an argument in some other context that the interrelationship of the polities of the states in the Commonwealth under Section 106 of the Australian Constitution creates other restrictions on states' powers to amend their constitutions, and that older cases that have turned on the characterisation of state constitutions as uncontrolled constitutions of the colonies may have to be reconsidered. There's one other possibility that this presentation may prove, and that is no baby boomer should ever be allowed a PowerPoint presentation. Thank you, ladies and gentlemen.